Convincing a jury of the monetary value of an intangible loss is one of the hardest things that we do, because no amount of money is going to put the person in the position that they were before the harm. No amount of money is going to bring a person back in the case of a wrongful death case. But all the law allows is money. We're not in Old Testament time, eye for an eye, tooth for a tooth, life for a life. We solve these disputes with money, and that's just all the recourse that a family can get for the loss of a loved one, or an injured party can get for their complete change of life. And so what the law designs, or what the law is the goal, which is an impossible goal, but is to give the person an amount of money that's a fair exchange, a fair trade for the harms and losses that they've suffered. And so in presenting the case, we want to be able to show in very descriptive detail what those intangible harms and losses are, with vignettes, stories of what they were like before and what they're like now, and then ask, what's a fair trade for that. We're prevented by the golden rule, would say you can't say, now jury, put yourself in the shoes of our client. How much money would it take for you to do there? You can't do that. That's not allowed. But you certainly want to show what those harms and losses are, what as best you can describe the pain, what the daily activities, how hard is it for the person to just cook a meal, or take a shower, the loss of enjoyment of life, what were their hobbies and interests? Were they an avid mountain climber, avid skier, avid just hiker? Did they like to take walks on the beach? Did they like to go dancing with their spouse, and can no longer do that? And then you present, okay, what's a fair trade? If our client could go back in time, would he trade $5 million immediately before the injury to be in that position? And typically the answer is no, absolutely not. And so you can then make an ask based on this doesn't seem like a fair trade, but this is what we're asking, because this is the minimum to make it right. And if you don't provide full amount of the loss, then you're rewarding and you're incentivizing negligent, incompetent behavior. And certainly as a society, we don't want to incentivize negligent, incompetent behavior. Folks that do harm should be held accountable to compensate for the harm that you that you make, right? It goes back to you break it, you fix it. Carter, did you ever have a time when you were young, parents took you to a store, you broke something?
I can probably think that happened many times. And there was 5 of us growing up, so I'm sure we broke plenty of things. But yeah,
any windows that you had to fix when you were a kid?
I can't think of a specific window. I've almost taken a few out on the golf course that I've had to fix. But one of the other things we haven't really talked about with the damages would be, most of our clients that have been injured are going to be dealing with these injuries, for the rest of their lives. And so I think one of the important things, in addition to all of the intangible aspects, is also talking about their future medical care and what they're going to need,
right,
going forward. And I think one of the ways that we do that is by getting a life care planner who goes to visit with the client and they do an evaluation of what kind of injuries is the client dealing with and what kind of needs do they have. What kind of doctor's visits are they going to require? Do they need attendant care to help them around the house? A lot of times you might have a person who's married and their spouse takes care of them all day long. They can't get out of bed and they have a lucky situation where they have someone that's there to take care of them, but it also takes away from that person's ability to live their life somewhat. They can't go to their job. They have to be at home to take care of their husband or wife at all times. And so one of the things that the life care planner considers is that you do need another person that you can hire that can actually come in to the house and help do a lot of those things, help take care of the person. And so I think it's super helpful to have someone evaluated and to determine what are they going to require for the rest of their life, because that's one of the things that the jury's going to need to consider as well.
Yeah, I know you're not a life care planner, but you've taken the lead in working with a life care planner that we've used. What talk about your understanding of the process of a life care planner, what they're doing, and then what a life care plan is, and your understanding of how they go about creating one.
So a lot of life care planners are actually also case managers for patients, meaning they follow along with patients who have been catastrophically injured and sort of follow them along for their life and kind of determine what they need medically. What kind of evaluations are they going to need yearly or every 5 years? Do they need, physical therapy a certain time or a certain number of times per year, occupational therapy? So they do that by not only looking at the medical records. That's the first thing they do. They have all the medical records. They'll look at mostly the physical assessments that are done after the injury. They want to know what the injury was, obviously, and then they'll go from there and look at just different assessments. What kind of strength issues does the patient have? What kind of cognitive issues? And from there, they sort of create a baseline plan, and then they go out and meet with the client and spend a good bit of time with them to learn about their injuries. And
when you talk about a good bit of time, we're talking an hour or two or more?
I mean, I think it's all day long, and or it can be. It just sort of depends on the case. But a lot of times they want to spend a good bit of time with the patient, and not only them, but their family as well, to get to learn again about those things that the person can and cannot do. And also they'll look into what kind of medications the patient or the client takes, and what are they going to need in the future, and just sort of how often are they going to need to be reassessed to determine if these are things that are still needed. And then they prepare a report, and they have another doctor, or they have a doctor who is qualified to do a physical examination, actually do the physical examination of the patient to confirm these are in fact real deficits that the person deals with, and then they sign off on the report and say that these are things that are medically necessary for that individual. And they'll usually put on the report how often they're going to require certain things. For instance, for attendant care, they might say this is a person who needs it just a couple hours per day. They might need help, with the cleaning and cooking around the house because they can't stand for long periods of time, versus someone who needs it around the clock because they can't get out of bed. They can't help take care of themselves at all. So they'll look at those and determine the frequency of each thing. If it's neurology assessments, how many times per year do they need to see a neurologist? How many times per year are they going to need physical therapy, occupational therapy? And then they just put all that together, and you can kind of get a picture of what this person's life is going to likely look like in the future and what kind of needs they're going to have. So that way you can then present that to the jury and have them determine, what is the value of that, and hopefully set your client up to where their medical needs are taken care of for the future.
Right. Yeah, because we have one chance to make a recovery for our clients, and most of our clients will need care far past the trial date, and so the life care planner is super helpful into projecting what future medical needs our clients will have and what the cost of that is, so that we can, when we make our ask before the jury, the jury has an opportunity to consider not only the medical bills that our clients have incurred up through the time of trial, but also can consider the the future medical expenses that they'll have going forward.
Yeah, and the life care planners do a lot of research to get, what are the rates for these services. I mean, a lot of times you might have someone who's already actively going to physical therapy, or they're being seen by a neurologist, and you can tell what are they being charged now and what is that likely, so they have that number there. But, you might have a client who doesn't have attendant care, for instance. They've got their spouse taking care of them, or a family member who's currently taking care of them, but the life care planner will do research and will determine what is the fair market rate for someone that you would have to hire, and they put that in their reports so that you know what the value of that is.
Right, and also a client with a spinal cord injury, that maybe they don't need surgery now, but in 10 years they're going to need surgery. So you would project out the cost of that surgery and include it in a life care plan as well. Carter, you're on the defense side for a good while. Did you ever have an insurance adjuster tell you that the plaintiff was malingering?
Yeah, a lot of the times they would think that. So I mean,
and what does that mean? What does malingering mean?
Essentially, either they're exaggerating their injuries, or they're not really that injured at all, and they're just faking it. And I think, like you said, one of the important things on our side is to let them meet our clients, have our clients tell their story, and for their story to be believable. I mean, if you have that, then it's hard to convince a jury that they're faking it. I mean, what defense attorneys and their adjusters will do is sometimes have private investigators go out and follow individuals to see how hurt they really are. So that's one thing that we always advise people that could happen, that they might try to get some footage of you if you're not as injured.
And we think that happened in our stroke case. Our client told us that he saw a truck and outside his house, and he went and asked what they were doing, and he saw that they were filming, and then the truck drove away. So it's something it's allowed. There's nothing we can do to stop it. And you're right. We let our clients know that it's a possibility that an investigator can come up and film them.
And I think one of the things that we always tell our clients is the jury wants someone they can root for, and so you want them to be able to tell their story in a way that's convincing to the jury. And to have the jury like them. And I think the first step to that is just in their deposition. Well, they are testifying in their deposition, and at the same time the defense is evaluating how is this person going to present at trial. Are they a witness that the jury is going to side with? Because that's very important in these cases. And also they're going to evaluate how severe are these injuries by watching the person walk in the room. Are they using assistive devices and all that kind of stuff.
So does that mean we want our clients to come in with a walker if they don't use a walker?
Absolutely not, because then the most important thing is you want someone who's honest. I mean, once they tell any sort of lie or they embellish their injuries, then you kind of lose credibility in all aspects of your case. I mean, that again, the jury wants someone they can root for. They're not going to root for someone who's lying or not telling the truth. And if you come into the office and you're using a walker, and then again you have someone who follows you with a camera and they catch you out there walking without a walker, then it's just going to backfire and it's not going to look good for anybody. So no, we always would say just come in as yourself, be yourself, and you'll win your case that way.
Right. Yeah, and to put a specific example in our stroke case, and we don't get to see the investigative video, but our client lived on a pretty large piece of property. Loved to work in the yard. He could still work in the yard. He could, and it was super therapeutic for him. And so at his deposition, he testified, yeah, I work in the yard all the time. And so if they had video of him working in the yard, then okay, it's consistent with what he said. Now, if he went in there and testified, no, I can't, I get too tired, I just can't do it, and they come in with video footage, then that's going to be huge impact on his credibility and taint the case.
Yeah, because it's not always that they can't do things. It just might be a lot harder. You know, you might have had an injury where it doesn't completely prevent you from doing the things that you used to do, but it might just take you a lot more effort, or it might just be something you can't do nearly as often. And I think that it's important to be honest about those things. Not say that you completely can't do anything, but to be honest about just the challenges that you face, and if it's things that you can still do, talk about the ways that it's just you're able to still do it, but it's just harder. And again, I think it goes back to the theme that we like to have someone you can root for and see that they're doing everything to live their life as best they can, and not let their injuries hold them back as much as possible. And I think by just being honest about the things that you can do, I think it really helps the jury see that.
Right, and the parlay you made me think of our recent prep up in New York, upstate New York, of a client who also suffered a stroke, and we during in deposition prep we also reminded her, like, yeah, you're saying you can't, you still cook, you still are able to take care of your kids. It's harder, and she did a really good job of testifying to that. And then one of the more powerful parts of her deposition was when opposing counsel asked, do you plan to go back to work again? And she's currently disabled, and she said, yes, I hope to get therapy and to be able to go back to work. And that was one of the more powerful components of her deposition, because it was just so raw and honest that she doesn't want to be disabled for the rest of her life. She wants to get better, and she's going to work to get better. And that's part of her damages story is and a lot of our clients' damages story is just how hard they're trying to get better, and that makes them human and somebody that a jury is going to want to help. You can't fix a weak damages case with a passionate closing. And I'm sure when you were on the defense, you saw numerous cases and numerous trials where the plaintiff's attorney railed on your clients for their carelessness, but just either overlooked the damages case or didn't have a strong damages case, and it didn't work. They didn't get if they got a verdict, it wasn't near the number that they had hoped for. We have to do the legwork. We have to get to know our clients, understand their harms and losses inside and out, meet with the family members, meet with their friends, meet with their neighbors, and get that story to be able to tell the jury. Because if we don't show it, how can a jury allow it in their number?